Well, this hearing will now begin. I want to wish everybody a good morning and a welcome. I want to thank you for attending this important hearing on the efforts of the United States government to address the issue of human rights violators from other countries who later come to the United States. I want to welcome, again, everybody, all the witnesses for being here. I want to give a special thanks to the staff of the Tom Lantos Human Rights Commission, Colleen Costello and Mike McVicker, for coordinating this morning's hearing, and I appreciate everybody who had a role in kind of pulling this thing together this morning. Since the end of World War II, the United States has maintained a generous policy of providing refuge for millions of people fleeing the effects of persecution and war in their home countries. A significant number of those refugees have been harmed and damaged by abusive and criminal behavior, and they bear the physical and psychological scars to prove it. According to the Department of Health and Human Services Office of Refugee Resettlement, approximately 400,000 current refugees are survivors of torture. Many more have suffered in other ways, from witnessing the needless death of family members to the destruction of their homes, places of worship, and cultural centers. All those individuals find a measure of safety and comfort in the United States and become part of our local communities throughout the country. We all can be proud of this tradition. Unfortunately, our nation's noble effort to protect the vulnerable at the time of their greatest need has also inadvertently opened the door to individuals who are in fact responsible for inflicting the very pain and suffering which requires the United States to act as a place of refuge. These human rights violators and war criminals take advantage of the openness of the United States to evade punishment or prosecution in their home countries, or to enjoy the proceeds of their crimes in our free and open society. These individuals sometimes reside in the same communities as their victims, causing further traumatizing in the process. It is true that some perpetrators have been victims of atrocity themselves, but they then attempt to use that fact as an excuse for their subsequent crimes. In fact, it is not an excuse. Finally, a few shamelessly and falsely claim to be victims when, in fact, the truth is that they only created victims. Whatever the reason and background, it is wrong that they are here. Starting with the attempts by the Department of Justice to track down and deport Nazis in the late 1970s, the United States government has gradually become increasingly focused on reversing the course of protecting those who have committed or assisted in human rights abuses. Today, both the Department of Justice and the Department of Homeland Security use a range of law enforcement tools and techniques to identify, investigate, prosecute, and remove human rights violators residing within our borders. There are teams of Federal agents, attorneys, analysts, researchers, experts, and historians who cooperate in enforcing criminal and immigration laws designed to achieve the same goal, ensuring that this country does not become a safe haven for human rights abusers. Also, there is a growing effort to improve information sharing amongst agencies and departments to deny admission to human rights abusers who attempt to gain entry into the United States. In addition, there is a role for those outside government to assist in efforts to end impunity. For example, various non-governmental organizations may work with victims to cooperate with U.S. law enforcement in criminal and immigration proceedings, or may pursue other legal avenues for accountability. There is also a need for various ethnic and cultural groups to engage with law enforcement and identify perpetrators in their communities. Today, the Commission looks forward to hearing from the two U.S. government agencies most responsible for investigating, prosecuting, and removing human rights violators: the Department of Justice's Human Rights and Special Prosecution Section, and the Department of Homeland Security's Immigration and Customs Enforcement. We will also receive testimony from the Center for Justice and Accountability, a victims' rights advocacy organization which has played an important role in supporting the work of these Federal agencies and has taken other steps to promote accountability. Although a Senate subcommittee has twice held hearings regarding current-day U.S. law enforcement efforts against human rights violators, there apparently has not been a hearing in the House of Representatives on this topic before now. So again, on behalf of the Commission, I want to thank all of our witnesses for being here, and we look forward to your testimony. And so our first panel will include John P. Woods, who is the Deputy Assistant Director, National Security Investigations Division of the Immigration and Customs Enforcement, Department of Homeland Security, and Eli M. Rosenbaum, the Director of Human Rights Enforcement Strategy and Policy, Human Rights and Special Prosecution Section, Criminal Division of the Department of Justice. So we welcome you here, and Which either one of you want to begin is fine with me. Mr. Woods, you lost the coin toss. You go first.
It looks that way. Co-Chairman McGovern, on behalf of Secretary Napolitano and Director Morton, I want to thank you for the opportunity to discuss ICE's role in ensuring the United States does not become a safe haven for human rights violators. ICE remains firmly committed to this mission and dedicates our resources for many programs in advancing it, including special agents in both criminal and intelligence research specialists from Homeland Security Investigations, our attorneys and historians from the Office of Principal Legal Advisor, and officers from the Office of Enforcement and Removal Operations. Today, ICE is handling more than 1,900 human rights-related cases involving suspects from approximately 95 countries, primarily in Central and South America, the Balkans, and Africa. Our successes and our ongoing daily efforts underscore ICE's deep commitment to denying human rights violators safe haven in the United States. To be more proactive in our efforts to prevent human rights abuses from entering the United States and to locate those who have entered, ICE established the Human Rights Violators and War Crimes Center in April of 2008. This center leverages existing personnel, missions, and authorities that ICE possesses to more effectively and efficiently harness our efforts against human rights abusers. The center was designed to bring together subject matter experts from various offices within ICE, in addition to other government agencies. Furthermore, within the center, ICE established regional support teams consisting of special agents, attorneys, and criminal researchers and historians with expertise in a specific regional target area or conflict. These regional support teams, considered the backbone of the center, are a valuable resource to enhance our domestic enforcement activities. A recent success highlights how well this approach has been working. In 2008, the Inter-American Commission on Human Rights revealed publicly the names of subjects involved in a 1982 gruesome massacre of men, women, and children at a Guatemalan village of Los Caceres. That massacre literally obliterated that small village. ICE and DOJ identified 4 subjects who were residing in the United States, 2 of whom had already obtained U.S. citizenship by naturalization. ICE opened an investigation, and the center developed case leads and coordinated with multiple agencies, both domestically and foreign, resulting in several arrests. DOJ played an integral part in this process and its success. In June of 2008, ICE created the Human Rights Targeting Tracking Initiative, which works to identify and target foreign human rights abusers and war crime suspects before they enter the United States, and to take the necessary steps to prevent them from gaining admission or immigration benefits. In furtherance of the Human Rights Targeting Tracking Initiative, ICE has generated over 3,000 subject lookout records of human rights violators suspects, and over 75 suspected human rights violators have been prevented from entering the United States. Assistance from a broad range of federal agencies and non-governmental organizations is a key component to the successful human rights-related investigation and prosecution. ICE's success has been dependent upon these strong partnerships with our domestic and foreign law enforcement agencies, as well as non-governmental partners. Human rights violator investigations require our special agents and the regional support teams to travel the globe collecting evidence and interviewing victims and witnesses. ICE maintains a strong working relationship with several dozen local, regional, and international organizations working in the arena of human rights. As part of our continuing efforts to enhance our capacity to prevent the admission of known or suspected human rights violators, as well as to increase our effectiveness in ongoing domestic enforcement activities, ICE has developed a comprehensive outreach strategy to government entities and non-governmental organizations throughout the United States. Within our own agency, with our expansive network of 48 attaché offices, ICE has further fostered our international relationships. When preparing a case for potential criminal indictment and prosecution, we partner closely with several DOJ components also, including the Human Rights and Special Prosecution Section, the National Security Division's Counterterrorism Section, the Office of International Affairs, and the individual United States Attorney's offices. Additionally, we seek to identify and prevent admission of foreign human rights abuse and war crime suspects. We work with our departmental partners at USCIS, Customs and Border Protection, and several bureaus within the State Department. ICE maintains close relationships with a number of United Nations-sponsored tribunals, including the International Criminal Tribunal for the former Yugoslavia, the International Criminal Tribunal for Rwanda, and the Special Court for Sierra Leone. We maintain an even wider network through our coordination with Interpol and their Fugitive Investigative Support Unit. In the spirit of late Congressman Tom Lantos, who tirelessly dedicated himself to raising the awareness of human rights around the world, DHS and all of its partners utilize every tool available to ensure that those who have committed such acts abroad never evade justice and accountability for their crimes. Co-Chairman McGovern, I applaud your continued leadership in these important issues, and I thank you again for the opportunity to address the Commission today. I would be pleased to answer any questions after.
Thank you very much, Mr. Rosenbaum.
Mr. Co-Chairman McGovern, it's a privilege to appear. It's a privilege to appear today before this commission, which strives to carry on the noble work to which the late Representative Tom Lantos devoted his life. As someone who first worked with Tom and Annette Lantos on a human rights campaign, specifically the effort to obtain the truth from the then Soviet Union about the fate of Holocaust hero Raoul Wallenberg back in the 1970s when Tom Lantos was still a professor at San Francisco State University and I was a law student on the opposite coast. It's a particularly moving experience for me to appear before a congressional human rights body that now bears his name. The Justice Department has been aggressively and proactively pursuing alleged human rights violators and war criminals, as the Chairman said, for more than 3 decades now, ever since the former Office of Special Investigations, OSI, was created in the Criminal Division in 1979 to investigate and civilly prosecute participants in genocide and other World War II-era acts of Nazi-sponsored persecution. OSI won acclaim as the world's most successful governmental agency pursuing justice in the Nazi cases. In fact, we continue to litigate and win those cases. Just last month, we won a court order affirming a victory we'd won in a case involving a Detroit area man, Ivan Kaliman, who shot Jews while serving as a Nazi policeman in Ukraine. In 2003, the Criminal Division created the Domestic Security Section, DSS, and assigned to it responsibility for, among other things, the criminal prosecution of certain post-World War II human rights violators and war criminals. DSS, too, was extremely successful in this work, most famously in the Chucky Taylor case, about which I'll have more to say in a moment. The center of gravity within the Criminal Division for the prosecution of human rights violators and war criminals is our new Human Rights and Special Prosecution Section, which was created last year at the initiative of Attorney General Holder and Assistant Attorney General Lanny Brewer by merging OSI and DSS in order to enhance the department's capabilities in these enormously important cases and also to realize significant operational efficiencies. HRSP's chief, who's with us here today, is Teresa McHenry, who has a distinguished record of pursuing justice in these cases, both at the former DSS and at the International Criminal Tribunal for the former Yugoslavia. In addition to the Criminal Division, the National Security Division, the Civil Rights Division, the United States Attorney's Offices, and the FBI all have important roles in the department's overall mission in the enforcement of human rights and international humanitarian law. The Department of Justice also works closely in these cases with the Department of Homeland Security, especially U.S. Immigration and Customs Enforcement, ICE, and the Department of State. And of course, we also work with many foreign law enforcement partners. Criminal prosecution involving offenses that were committed in another part of the world and that typically were perpetrated years ago almost invariably present difficult challenges. However, it is indeed possible to succeed in these cases. For example, one of the predecessor components of HRSP, DSS, together with other DOJ components, particularly the U.S. Attorney's Office for the Southern District of Florida, tried the first case under the federal torture statute. Roy M. Belfast, also known as Chucky Taylor, the son of the former Liberian President Charles Taylor, commanded a notorious Liberian paramilitary organization, and between 1999 and 2003, he committed multiple vicious acts of torture, including burning and shocking victims. Belfast was convicted of, among other things, 5 counts of torture. He was sentenced last year to 97 years imprisonment. This landmark case was investigated by ICE and the FBI. Prosecution under the federal criminal statutes covering genocide, torture, war crimes, and use or recruitment of child soldiers is not always possible. The conduct may have occurred prior to the effective date of the statute of limitations may have run, or the perpetrator may not fall within the particular jurisdictional requirements of a given statute. In these situations, we look to other viable bases for prosecution, such as statutes that criminalize visa and naturalization fraud, or civil denaturalization and subsequent removal from the United States by ICE, or extradition to countries that are willing to prosecute the offenders. Our legal arsenal also includes the Military Extraterritorial Jurisdiction Act, or MIJA, which permits us to prosecute some former U.S. military personnel and certain current or former contractors for crimes committed outside the U.S., including murder, manslaughter, assaults, and other violent crimes. Similarly, specified conduct can be prosecuted under this country's special maritime and territorial jurisdiction. Leveraging the enhanced resources and strong Justice Department and Criminal Division backing given to HRSP on its creation last year, our new section quickly achieved important successes. For example, HRSP and the U.S. Attorney's Office for the Southern District of Florida, with important assistance from the Criminal Division's Office of International Affairs, prosecuted a participant in the 1982 massacre of the inhabitants of the village of Dos Eres, Guatemala, as Mr. Woods indicated, one of the most notorious human rights crimes in Central American history. Gilberto Jordan, who immigrated to this country in 1985, was prosecuted for unlawfully procuring U.S. citizenship. At his plea hearing, Jordan admitted that the first victim he killed at Dos Eres was a baby. Evidence of the underlying crimes was relevant to the misrepresentations he had made when applying for U.S. citizenship, and last autumn, Jordan was sentenced to the statutory maximum term of 10 years in prison. The case was the result of a very successful partnership among OSI, later its successor HRSP, ICE, and the U.S. Attorney's Office for the Southern District of Florida. MIJA was instrumental in the prosecution of Stephen D. Green by one of HRSP's predecessor components, DSS, together with the U.S. Attorney's Office for the Western District of Kentucky. Based on an investigation by FBI and U.S. Army CID, the department obtained the conviction of Green, a former Fort Campbell, Kentucky soldier, on charges arising out of the 2006 rape of a 14-year-old Iraqi girl, Abir Qasim al-Yanabi, and the murder of that young girl and her entire family in Iraq. Green was subsequently sentenced to life imprisonment. The department's National Security Division also plays an instrumental role in the prosecution of human rights violators. For example, in 2007, its counterterrorism section, along with the U.S. Attorney's Office for the Eastern District of North Carolina, obtained the conviction of David Pissarro, a contractor for the CIA in Afghanistan, who in 2003 severely beat an Afghan prisoner. The prisoner, Abdul Wali, died while still in custody. Pissarro was convicted and sentenced to 80 months imprisonment on the most serious charge on which he was convicted, assault resulting in serious bodily injury. The Criminal Division is also actively engaged in work with foreign law enforcement authorities. OIA takes the lead in executing foreign requests for legal assistance and handling requests for extradition of human rights violators in this country. For example, 3 months ago, OIA, the U.S. Attorney's Office for the Southern District of Florida, and the State Department successfully extradited to Peru Telmo Hurtado, also known as the Butcher of the Andes, a former Peruvian military officer charged with the 1985 massacre of 69 people in the village of Acamarca, including pregnant women, the elderly, and infants. The Criminal Division's Overseas Prosecutorial Development and Training Section, OPDAT, and our International Criminal Investigative Training Assistance Program, ISITAP, take the lead for the department in providing training and assistance in criminal justice sector reform and development. As you can see in the Criminal Division, we like sections to have really long names. OPDAT's work has significantly enhanced bilateral cooperation on war crimes cases, especially among successor countries to the former Yugoslavia. In conclusion, the Justice Department is deeply and abidingly committed to pursuing justice on behalf of the victims of human rights violations and war crimes. We will continue to use every tool available for enforcing U.S. law, strengthening the rule of law in other countries, ending impunity for human rights crimes and war crimes, and ensuring, in cooperation with our colleagues at ICE, FBI, and elsewhere, that this country is not a haven for human rights violators and war criminals. Thank you. I would be pleased, very pleased, to respond to your question.
Well, let me say thank you to you both, and not only for your testimonies, but for your service, and to those in the audience who work with you, both in the governmental part of this effort and in the non-governmental part of this effort. I want to express a very strong thank you, because I've worked on human rights issues for a lot of years, and I think that if you want to stop these kinds of violations, I think it's really important to show that if you commit them, that there is a price to pay, that you will be held accountable. And in so many instances, there are cases where people all around the world commit terrible crimes, and they're not held to account. And I can't help but think that that's somewhat encouragement for people who want to commit human rights violations. Let me, Mr. Woods, if I can begin with you. You mentioned in your testimony that significant gaps still remain with respect to the types of human rights abusers who are inadmissible to and deportable from the United States. For instance, human rights abusers who have committed or assisted in persecution cannot be denied entry or deported on that basis alone. Could you describe what other gaps in the law might exist, and what you might recommend Congress to do to fill in the gaps? And I would encourage you both, and all those who are testifying today, to please feel free to give us advice and tell us what we should do to help strengthen your ability to hold human rights abusers to account.
Certainly. Excuse me. Certainly. Aside from that cited example, certain other loopholes that exist would contain to existing statutes as they relate to offenses such as visa fraud, false statements, and the statute of limitations. On visa fraud, you have a 5-year statute of limitation, and on naturalization fraud, you have a 10-year statute of limitations. So that limits at certain cases, us taking a criminal stance against these individuals when the substantive crime of the genocide or torture cannot be proven. Additionally, due to ex post facto issues, the recently enacted criminal statutes on the recruitment of child soldiers or genocide are only applicable to recent conduct and not to past conduct. And finally, I would recommend one of the issues would be sentencing enhancements related to human rights violators. There's no sentencing enhancement guidelines related to that when you come to visa fraud or naturalization fraud.
Well, all right, Mr. Rosenbaum, well, let me just kind of building on that question. I mean, under current federal law, the statute of limitations to prosecute an individual responsible for the theft of major artwork is 20 years. In contrast, the statute of limitations to prosecute an individual accused of torture is only 8 years, and the statute of limitation to prosecute an individual accused of recruitment or use of child soldiers is 10 years. I think I'm right on those. If I'm not, correct me. But are you able to say approximately how many cases your agency has been unable to pursue because of the statute of limitations? And would it be a wise thing for us to, revisit this issue? And I mean, it's hard to believe that there's a statute of limitations for torture. But I'm curious to get your input.
I don't have a number for cases that could not be prosecuted.
But I assume that there is some, yeah.
Yes, this has been an issue. We certainly have thoughts about the possibility of extending statutes of limitations, and we think that's important. And we would be pleased to work with the Commission and with the Congress on that.
Yeah, well, I welcome that invitation, because I think that's something that we're very interested in, working in a bipartisan way to try to figure out whether we can deal with that issue. I spent a lot of time when I was a congressional aide for Congressman Joe Moakley working on issues regarding El Salvador, and one of the things that has always puzzled me is that some people some individuals guilty of human rights abuses, were able to kind of freely go to the embassy and give their real names. It wasn't like that. Some of them snuck in, some gave their real names and were given visas, and their status was legalized here in the United States, notwithstanding the fact that there was overwhelming evidence that they were involved in some bad things. And one of the cases that always kind of puzzled me was the case against the former Salvadoran generals, Jose Guillermo Garcia and Eugenio Vidas Casanova, known as the two generals. They were involved at a minimum in the cover-up of the murder of 4 American churchwomen, a whole bunch of other things as well. But this was a case that was directly involving American citizens who were murdered. But they got in here pretty easily. I mean, and I remember when I found out they were here, I remember calling, I think it was State, trying to say, how could you let these people come into the United States? I mean, surely there was a file on these individuals because there was lots of press attention, but nonetheless they came in. Now, since then, there have been actions against them. But I was wondering whether or not, Mr. Woods, you might be able, or Mr. Rosenbaum, whether you could give me a kind of a status update on the cases against those 2 individuals, if you know offhand.
Right now, both individuals are in removal proceedings before the Immigration Court. We're expecting in January of 2012, the hearing is completed, but we're expecting in January 2012 a decision on the Vidas Casanova case. And currently, the Garcia case, which is in removal proceedings, has not yet been set for its hearing.
Right. But obviously, things have progressed in terms of our government kind of cracking down on this issue of human rights abuses coming to the United States. But, I mean, again, I go back to the case of these 2 individuals who did not sneak across the border, who came in here, and applied for all the appropriate statuses legally. Mm-hmm. I'm just curious, how does something like that, I mean, I think this was like in the early 90s. I mean, was there not a policy in place to kind of screen some of these people out? I mean, again, this was a case involving Americans, and to this day, it just puzzles me that someone at the embassy, who actually got the application, didn't say, "Hey, this is Vidas Casanova. He was involved in the, in a very notorious case that received a lot of attention." I mean, when did the vetting process get a little bit stricter?
I can't address what the State Department practices were in the 1990s, or I suppose at any other time. That's for the State Department to address. I can say that the problem of inadequate vigilance in screening potential immigrants and applicants for refugee status, asylum, is a long-standing one. Hundreds, at least, of Nazi war criminals managed to get into the United States without changing their names. And for all of us who work on these cases, it's been a source of considerable frustration. I think we can say that keeping these people out is our first line of defense. Right. It's the top priority. And one can also say that the White House, through the President's announcement in August, his proclamation, that for the first time war criminals and participants in crimes against humanity are ineligible to enter the United States, really elevates the effort significantly to bar these people from entry.
Mr. Rosenbaum, you had referenced this in your testimony. The Office of Special Investigations has made tremendous contributions to initial U.S. government efforts to hold human rights violators accountable in its work against those who assisted the Nazi-led persecution. What do you think are the most important lessons from the Nazi-era cases that are applicable to the modern-day cases? And are there any active Nazi cases remaining?
Yes, Mr. Co-Chairman. To take the last question first, we have several cases still in litigation, including the Kaliman case out in Detroit. I think one of the lessons that we've learned is that it is possible to prove the underlying conduct even decades after the crimes were perpetrated. It's certainly not what we as prosecutors prefer. We would much rather have a fresh crime scene, if we have to have crime at all. But these cases can be proved. They are exceedingly difficult. We learned that in the World War II cases, and we see it again in the modern cases. We learned in the World War II cases that one can find witnesses, and it's inspiring to meet them and to see how they reopen these psychic wounds that can't ever heal in order to help educate our courts. Many years after Chairman went to El Salvador, I had the experience of going there and being inspired by people who were risking their lives just to meet with us. So these cases can be brought, but they're fraught with challenges.
What is DOJ's post-case evaluation of the Department's decision to dismiss the charges against Lazar Kobagaya, who was implicated in the Rwanda genocide?
After the jury reached its decision in that case, the government identified a potential issue regarding the clarity of the legal instructions that the jury received regarding whether materiality was an element of the visa fraud count. We had charged both visa fraud and naturalization fraud, and he was convicted on visa fraud. The jury hung on the naturalization fraud count. We also identified information provided by a witness that, when considered in conjunction with the lack of clarity in the jury instructions, would likely have warranted a new trial on the visa fraud count. And based on the totality of the circumstances, and these are always very complex analyses, including the substantial resources that would have been required to retry the case and potential trauma to our victim witnesses, we determined that we would not seek to retry the case.
Mr. Woods, can you please explain the role of DHS in the visa issuance process vis-a-vis the State Department, especially in terms of preventing human rights violators from entering the United States? I mean, may DHS prevent the issuance of a visa to a known human rights violator? And are there visas or other immigration mechanisms in which DHS does not have a role in preventing human rights violators from entering the country?
Our process in assisting the State Department in making the decision on visas relates to our, like I said in my testimony, our Human Rights Target Tracking Initiative, where we put subject records into the system that interfaces with CLAS, their visa issuance system, to identify human rights abusers that are foreign that may be applying for benefits, or additionally those people who may have applied for benefits and seeking the revocation of their visa. We have research specialists that research these events overseas, identify the perpetrators, and then make sure they're identified in the U.S. government databases to ensure that there's a sound decision made by the State Department consular officer. In many cases, this may go to a special advisory opinion where it goes through an interagency process prior to determination whether a visa would be issued to the individual. And that it's a decision that's made on a case-by-case basis based on the evidence that we're able to provide.
I hate to go back to El Salvador. There's another case that I've been concerned about, and that's the case of Colonel Montano, who was involved in the Jesuit murders back in 1989 in El Salvador, who was arrested in August of this year in Massachusetts, of all places. What's the status of that case?
That has not yet gone to trial. It's been charged on a criminal complaint charging visa fraud. Right. And because it's in litigation, it really wouldn't be appropriate for me to discuss it any further.
All right. And I don't know if this is an appropriate question for me to ask, given what you just said, but you know, as you know, there's a judge in Spain who wants to reopen the Jesuit case, and you know, there may or may not be a request for extradition for Colonel Montano. Do we have if the United States were to receive such a request from the government of Spain, would we be likely to comply with that, or is that not an appropriate question for me to ask?
It's a fair question. I can't address the specifics of that case or predict the result in any particular instance of an extradition request. What I can say is we do have an extradition treaty with Spain, and that extradition requests from Spain and other countries with which we have treaties are expeditiously and capably reviewed and get a fair hearing at the Department of Justice and at the Department of State.
Again, let me close, going back to what we talked about earlier about this issue of the statute of limitations on some human rights crimes. It seems to me that it makes sense to revisit that issue because, again, I mean, as we've learned, in the case of the Nazi war criminals, sometimes, the truth doesn't come out for a while, and so to put an arbitrary kind of statute of limitation on some of these crimes doesn't make a lot of sense. Is there a reason? I mean, I'm trying to say how did somebody come up with? And this is not, you didn't do it. I'm praising the work you guys are doing, but I'm trying to think about what kind of thought process went behind putting was it 8 years on torture? I mean, again, I compare that with 20 years, for the theft of major artwork. Then it should seem to me it should be the other way around. But I'm curious what the rationale behind those statute of limitations might have been.
I'm afraid I don't know what Congress had in mind, nor do I know actually whether the Department of Justice had a view on that back then.
Well, I welcome your offer to work with us to try to, and I think that's something that people in this commission in a bipartisan way would, I think, look forward to working with you on. Maybe both of your agencies trying to figure out whether we can get this right, and so I thank you. I thank you very much for your testimony. We're joined by one of our fellow committeemen here, Congressman Joe Pitts of Pennsylvania, and I'd like to yield to him at this particular point.
Thank you, Mr. Chairman. Thank you for holding this important hearing. First of all, what role do you play in advising the State Department if there's a request for a travel visa from some foreign leader who has been implicated in human rights violations? I remember, and I think it was after the 2002 riots in India, in Gujarat, where 2,000 innocent people were slaughtered just brutally. I visited there after that, and I visited the home of the ex-parliamentarian Jaffrey, where 72 women and children had fled for refuge, and they had been brutally murdered and burned. The Prime Minister of Gujarat province was implicated in that case went up to the Supreme Court of India. And because of that, our State Department denied him a travel visa to come and speak to a conference here in this country. That very rarely happens. Are you involved in that kind of role in investigating backgrounds in countries of human rights violators and recommending to the State Department whether they grant or deny a visa?
Well, as in the case of ICE, we have our own complement of country specialists, historians, who are capable of doing a considerable amount of research on issues involving conflicts in other lands. And there have been instances in which the State Department comes to the Justice Department for that kind of information, and of course we provide it as best we can.